planning is the start of it. And I always tell clients, it's not the end all be all.
Okay.
Generational wealth, and that's a topic I've been trying to sort of hone in on and share with my clients, because most people think, hey, I just have to do estate planning and that creates generational wealth. But generational wealth, and I know this is a little bit off topic, but generational wealth is
Hi, this is Natasha Bazile with soldbynat.com, associate broker with Virtual Properties Realty. I am your relocation, new construction, and home selling specialist in Georgia. And today I have a very special guest, attorney Thua Barlay. Did I say that right? Is it Barlay or Barley?
Barlay, and the H is silent, so it's just Thua, like
Thua. I just jacked it all up. Okay.
You're fine.
I know.
I hear so many different things. Exactly.
Okay, I'm sure you get it. So thank you. Thank you for being here. And we are going to talk about, you're a real estate closing attorney. You're an estate planning attorney guru. So I have some questions for you. I have some questions from others, but it was important for me to have you on while my channel is real estate focused, for creating content for buyers, sellers, homeowners. I feel like this is a natural extension. Like, okay, you work so hard, you acquire these assets, and then what? What do we do with it? So that's why I wanted to have you on here. I will say, not only think highly of him and wanted to share him with you, but I am also a satisfied customer. Because my husband and I got our estate plan done. And we're going to talk about that too. And I see you have a binder back there as well. So before we jump into it, I'm going to allow you to share a little bit about you. Like, how long have you been in the business? Any information? I'm going to hand it off to you.
Perfect. Thank you, Natasha. Again, thank you for the invite to share some of the knowledge here on your channel. Again, my name is Thua Barlay. I'm an estate planning and real estate attorney. I've been doing real estate transactions for 20 years, almost 20 years since I've been barred, and I've been doing estate planning for about 15 of those years. As you mentioned, to me, estate planning and real estate are sort of synonymous. They're very close in the sense that typically most of my clients, their most important assets happen to be their primary residence or their real property. And so for me, when I was looking at what other practice area did I want to go into to sort of complement real estate, estate planning was that sort of natural extension. I've been doing it for a while and enjoy it. I meet clients on the best of terms and help them organize and get prepared for the inevitable situation where they're no longer either capable to handle their affairs or they passed away. And so that's really in a nutshell, what estate planning is.
Okay, wonderful. You mentioned that you meet some people on not the best of terms, we can imagine. And you also mentioned that it's inevitable. Many people just don't plan or prepare for it, I guess, because those conversations aren't easy, aren't glamorous, but they need to be had. Like, I refuse. And if you see a post after my passing about a fish fry or a GoFundMe, I need you to shut it down. And that's why, that's one of the reasons why I do not want my family to have to scramble, try to figure it out. I just feel like that's the worst thing. When somebody passes, you just be able to mourn. That'd be it. Don't have to worry and figure out and guess what I want. And then comes in the bickering and all that stuff,
I'm an estate planning attorney, and I have to say my father passed away about 6 years ago. Again, been practicing estate planning, never had the conversation with me, could never broach it with my father. And so he passed away without a will. So I can understand those situations. And one of the discussions that people have after you pass away is not necessarily how to spend or where do we find the money to spend on it, but sometimes it's the little decisions. Where are you going to be buried? What hymns are going to be sung? That's why I had you and your husband, but I have everybody do that simple exercise of memorial instructions, telling people exactly how you want your funeral to be conducted. It relieves the family members of those discussions and decisions because they know, again, that this is something that you wanted to have happen. So not mandatory, as we talked about, but it, again, helps along with that conversation.
Yeah, definitely. And yeah, again, it was tough conversations, but my husband and I kind of made it light. We would like go out to lunch or dinner or whatever and kind of just talk about it. Like it needed to be talked about, and we got it done. So let's start on the real estate closing side of things, because that's also my first introduction to you was through a real estate closing, and it was also the buyer selected. She wanted to close with you. Shout out to Tiffany. She wanted to close with you because either you were already working doing estate planning, or but she wanted you to be her closing attorney. So on that front, when as an agent, we're looking at listings and it says the preferred closing attorney is XYZ. Correct me if I'm wrong. It's a preference. It is not mandatory. Like that is negotiable.
Correct. That is negotiated between the listing agent and the selling agent. And we always say whoever has the better leverage tends to pick the closing attorney. So we try to be as amenable to both parties as we can. But we try to do a good job. I think at the end of the day, this is we're not necessarily a commodity. So closing attorneys, there are quite a few of us for you to choose from, and for the most part, everything are similar. The way I like to distinguish myself is I'm OCD, and that means I pay special attention to the details, not only in terms of my staff when we get the contract in, the things and how we follow it, but also at the closing table, making sure that the documents are properly explained. Again, I'm OCD, so every single package has the exact same order of a closing, which most people, it blows their mind that you would do that, but it makes it easier for the buyer and the seller for them to be able to sign and be able to understand what they're signing.
Okay. All right. Great. And along those lines, for you watching, I did a video with Jeanette Franklin. She was a past client. She always told me, one day I'm gonna get my real estate license. I'm gonna come work with you. And that she did. She got her real estate license as she's building her business. She's working with me as my client care coordinator. But we did a video because she had several years of working on the closing attorney side. And she was sharing like, it is important to get the closing attorney certain information, what they're asking for in a timely manner, because you guys have work to do to prepare for closing. It's just not something that we can leave towards the end. Do you find that to be sometimes like pulling teeth?
We do. Sometimes, especially with our cash transactions where people are saying, hey, it's a cash deal, we want to close quick. And that's great. We can close quick. Make sure particularly on the seller side, that you fill out our questionnaire, that you tell us where your payoffs are, that you tell us if there's a homeowners association, who is the property manager or who the contact is at the HOA. Some of these things so that we can order in advance and be able to prepare for it. Because we're typically, when we get a contract in, we send out a title examiner request. So we send out to an examiner that we want you to review the title on this property and give us back an abstract. The attorney will review to make sure everything is taken care of. And while we're waiting for that, it's the best time to get the seller to send us back everything that we need so that we can order payoff, order the HOA closing letter, or anything else that we need, termite letter, receipt of that. So there's a lot of moving parts, and we are sort of that instrument that sort of brings everything together to provide an end product.
Thank you for providing that perspective from the other side. The other thing I want to mention or ask you about is adding people to title or to the deed. Yeah, I get it. We get a lot of it. Sometimes when we purchase, when my husband and I initially purchased, it was in his name. He added me to the deed. We were husband and wife. Like, do you get it to where people are just like, I want to add my child, or I want to add my boyfriend, or I want to add people. What would you advise on that topic?
So it's a great question, because we used to get a lot of those requests. We still do. Our title insurance underwriter came up with a policy, because apparently they must have been receiving several claims of issues that come about when you add people that are not directly related in terms of spouses. And so our title underwriter came out with a sort of a policy that we could not add anybody other than a spouse on title at the closing. Now, months from now, years from now, you can do whatever you want to, but at the closing, we cannot add. In fact, last week, we just had a request to add a girlfriend on title, and we had to politely say, unfortunately, we can't do that. Now, the lawyer in me, and I always have to explain it to people, understand that that's an irrevocable transfer, meaning that when you add somebody on, you can't simply take them off by yourself. They are now considered an owner of the property, and they have to sign off. In fact, I remember years ago, I had a situation where we did add them based on their request, and months later we get a call back. Hey, we broke up. I can't seem to find this person. I'd like to take them off title. And unfortunately, we said they have to sign a deed to get taken off, and you may have to go to court if you can't find them to allow the court to make that sort of decision and provide the remedy. And being a transactional lawyer only, I couldn't walk them through that process of what it would take to go through court. But again, as you mentioned, it's a conversation that you really need to have, especially children. Adding minor children is definitely not advisable, because if you pass away while they're minors, the law says that anybody under 18 cannot own property or not deemed to be competent to own property. So if you pass away and they're under 18, they're considered incompetent, and a guardian or a conservator would have to be appointed to be able to manage those properties for them. So again, I know this is a perfect segue to why it's important to have estate planning, because sometimes people try to make these shortcuts on getting people on title instead of what they should be doing, which is a proper estate plan that would add them on in the eventuality that you pass away, or let's say you become disabled.
Okay. So that is definitely not something to be taken like. You need to give a lot of consideration, and especially because everything's fine when it's fine. But when it's not, it's not. And it's just like you said, I'm so glad you said that. It's not just a simple call like, okay, take them off now. You are giving them ownership. Absolutely. Ownership in your, yeah. Okay. So you explained that very, very well. So that is going to transition us into estate planning. So you do have a YouTube channel, which I will link in the description box, and you have a video on there that talks about the difference between a will and a trust in the state of Georgia. So that has great information in it. So we're just going to touch a little bit on some topics, but definitely please go ahead and subscribe to Thua's YouTube channel. Yes. And watch that video. When it comes to a will and a trust, the general question is the difference between a will and a trust.
Well, thank you. And Natasha, as you mentioned, again, the longer version of what I'm about to say is on that video. I've been delinquent in getting those videos in there as they need to. But the first and most important is one that I always get a question on. Tell me the difference between the will and the trust. So the video will expand on what I'm about to explain to you. But I always like to use the analogy of a car, the same make and model type of car. So you have a will-based car and you have a trust-based car. Now, with the will-based car, when you pass away, that car has to go into the shop to get tires rotated, oil changes, etc., before it's ready to go on the journey. With the trust-based car, when you pass away, because you've been doing tire rotations and oil changes throughout the life of the vehicle, it's automatically ready to go on the journey. So that really is the main difference between a will-based plan and a trust-based plan, is the fact that with will, it has to go into the shop, which in the analogy is the probate court. So you submit or petition the will in a probate court. The probate judge appoints the executor, and then it's ready for that executor to make all the decisions around the estate. Same, unlike the trust, upon signing, it becomes effective. And so when you die, that trustee is automatically going to replace you in that car, and he or she is ready to follow your instructions and take that car off. So that, in essence, is the main difference between a will and a trust. And the reason why I also say will-based and trust-based is because the will and the trust are the central documents in a plan. Especially in a will-based plan, because you have to go to that shop or to the probate court, a will doesn't become effective until you pass away. And so during periods of disability, we know for a fact that a majority of us are going to go through a period of disability before we pass away. So the question is, if we only know what documents do we need to have in place to cover that period of disability? So in this case, it would be the powers of attorney, the advance directive. Those are things that handle decision making for us while we're disabled. Now, the trust becomes effective upon signing, so you don't necessarily need those documents, but we prepare them nonetheless because there are situations where you don't necessarily, because the trust is a contract, it's a private document, you don't always want to disclose the terms of the trust, so you would have the power of attorney and the advance directive as part of this plan to submit those documents so that people can make decisions on your behalf. But in a nutshell, that is generally the difference between the two.
Got it. Okay. All right. So does everybody need to have one or the other?
So that's a great question. The short answer is yes. Obviously there has to be some considerations made depending, it's almost like a cost benefit analysis. Do I have assets that I need to properly plan for to be able to pass on to someone else? So I typically, if you have a home, absolutely, you need a will. In general, there are what we call the world, or the probate world is separated into two areas. It's the probatable estate and the non-probatable estate. So, the best way to do it is to explain the non-probatable first. So the non-probatable estate is any asset by contract or by law goes to a particular person. So in the instance, let's say life insurance, where you've designated beneficiaries to your life insurance policy, they would not be in your probatable estate. They'd be in the non-probatable because by contract, they go to your beneficiaries. The probatable world are things, again, that don't automatically go. So primary residence, where you alone are on the property, yes, when you pass away, it goes into your probatable estate. So you could, in some situations, if you properly organize where you have non-probatable assets, you could get away with listing beneficiaries on those policies and not have to have a will. But again, we're talking, the exact day that you're going to pass away. That all your beneficiaries, because most of these policies give out directly to the beneficiary. So in some situations where you may say, I think that this person needs to get all these funds outright. Maybe they need it at a particular point in time or a particular age or a particular attainment, whether it's education, job, or anything else. If you have any restrictions in place, you need a will or you need a trust to make those, or else by law or by contract, it'll go directly to them. So in essence, in a nutshell, or my short answer is yes, everybody does need a plan, whether it's a will or a trust, depends on several factors.
When you were talking about the will and it goes to probate, how long does probate take, or can probate take?
Yeah.
Are we talking about a week?
Yeah, no, it depends. The good news is, fortunately, and I practice primarily in Georgia since I'm only barred in this state. But the good news for people who are residents of Georgia, in comparison to other states, Georgia has shorter time frame on probating an estate. But we're still talking months, at the minimum 3 months, particularly if the judge decides that there has to be publication to your creditors that are known and unknown. So it's published in the local organ for at least 4 weeks. So the minimum is probably 2 months from start to finish, because not only do you have to complete the petition, but the heirs of the estate have to sign off on the petition. So there's a lot of process that goes on with probating a will. So I would say on the low side, 2-3 months. On the high side, it could be years, depending on if people get along, depending on the assets. Because the main responsibilities, there are 3 main responsibilities of your representative. Now, the representative is called an executor if you pass away with a will, or an administrator if you pass away without a will. But their responsibilities are the same in essence. There are 3 main things that they're responsible for. The first is to gather your assets. Second, to pay off creditors. And third is to distribute assets. So again, gather assets, pay off creditors, and distribute assets. Because they have to do a lot of these things, it may take some time to be able to do that. They have to know the creditors that are being paid off. And so there's a lot of moving parts to the probate process.
Pay off the creditors, so they're gonna get their money.
Correct, and that's number two. So before you give anything out to anybody, you have to pay off creditors. There's no getting around it. There's even in the law, it tells you it gives preference to certain creditors. So there's a list as to which creditors have priority, but at the end of the day, they have to be paid off before any monies are given out, period.
Okay. All right. And when it comes, this is a good one. So, in real estate, on the realtor side, people are like, well, I don't need a real estate agent. I'll just do it myself. And we call those FSBOs. I'll sell my home on my own. There's these things going around like, just do your will yourself. I am the type, I believe in going to professionals that do this for a living versus me trying to be a jack of all trades and put stuff in place. Like there's no way I could have done this estate planning, the stuff, by myself at all. And even a will, some people might say, well, I'll just write stuff down on a paper. But from watching your video, reminder, go watch that video on YouTube channel. That's not enough. It just can't be a document that says, hey, I wrote this.
Correct. There are certain formalities in a will that have to be done. They have to be witnessed and notarized. The witnesses have to be 14 years of age or older. So there are requirements. And is there a place for the fill in the blanks online forms that you see from various places? I was going to call out a name, but I'm not going to. But you see it very often. And is there a place for those companies and websites? Yes. But what I tell people all the time is you don't know what you don't know. So filling out a blank may sound easy. And again, if your estate is one of the most simple ones, then perhaps that may be fine. But again, it's always important to get a professional who does this. People don't pay me because I necessarily prepare documents. They pay me for the knowledge that I have to be able to ask the questions that are necessary to draft the documents. Because we try to customize every document to the client. So not everybody's plan, your plan is not the same as mine. It's not the same as my neighbors. Everything is a little bit different. And that comes about from the estate planning attorney knowing to ask these questions so that they can sort of differentiate out things that are important. And so I would again emphasize, as you mentioned, a profession, whether it's real estate, whether it's estate planning, whether it's financial advising, insurance work. You always need a professional to handle those things because they are the ones that have gone through the necessary educational process to become well-versed in that particular area.
I think you kind of answered this question, but this question was, does a single person or someone with only one child need a will? Because I talked to somebody and they had the mindset, well, I'll just list her as a beneficiary on everything. And I know you spoke about that, like, okay, that could work. But then I'm like, but you have properties in other states, you have properties and such as like, how is that going to work? So it was just me.
There are a couple of things in your questions / statement that I will address. So yes, now in terms of the simplicity of your estate, yes, a single person with one child, and let's assume that one child is also over the age of 18, competent, good job, no issues, married, kids, or whatever the situation is. Yes, I can see where that would be a very simple estate, but there are still considerations to be had. So the other question is, well, what if that one child passes away? Do you want to give to the grandchildren, or do you want to give to your siblings or to other people? So there's a lot of considerations when people say I have a simple estate. It is simple until you start asking the questions and realize, no, that there's a lot of differences there. Now, properties in different states. We talked about the difference between will and a trust, but there are several factors to determine whether I recommend trusts to clients as opposed to wills. Things like, do you own a business? Do you have properties in different states? And that's important because if you have properties in different states, understand that with a will-based plan, you're going to have to probate in the state that you pass away or that you're resident of, in this case, Georgia. And then you also have to probate the estate in that other state. So if you have properties in different states, I typically recommend a trust, because with a trust that is properly funded, and I can't stress that enough, that the assets are properly directed into the trust. And that's what funding is transferring the assets from your individual name to your name as trustee of the trust. Once that process is done with a fully funded trust, then we no longer have to do a probate in Georgia, as I mentioned earlier, but we also don't have to do a probate in the other state. So now you're avoiding two probates as opposed to in the earlier differentiation where you were just avoiding one probate. So again, the factors, but again, online forums won't be able to necessarily ask you all those questions about properties in different states and what you want to have happen. And tell me a little bit about your child and what they're doing and how well they handle money, things of that nature. Because again, you're leaving those assets to your children. And yes, I get this all the time. People say, I'm not going to be here, so I don't really care. And that's fine, and that's understandable. But again, you avoid any dissension or any issues that may come about as a result of you leaving funds to somebody. And again, these are assets that you've worked hard over a period of years to acquire. And so you want to make sure that it's properly accounted for.
Yeah, definitely, especially because I know generational wealth is a term that, people are using a lot. But at the end of the day, we work so hard I'm going to assume everybody thinks like this, but you're working so hard to provide a better life and to provide for your family. Like, I just don't want it to stop at me. Like, I want it to continue on and leave that legacy. So that's why it was also important.
And estate planning is the start of it. And I always tell clients, it's not the end all be all.
Okay.
Generational wealth, and that's a topic I've been trying to sort of hone in on and share with my clients because, most people think, hey, I just have to do estate planning and that creates generational wealth. But generational wealth, and I know this is a little bit off topic, but generational wealth is also a mindset. So preparing documents may not necessarily create generational wealth. Acquiring the wealth may not necessarily create generational wealth. What really, in my humble opinion, that creates it is that communication. It's that upbringing of your children, particularly, so that they can carry that on. Because if you create it and build it up, and you haven't properly armed them or educated them, then it's going to end with them as opposed to generations down the line. And you can protect and create as many restrictions in a trust as you want. But I think that educational mindset on your loved ones is the most important part of that.
I am so glad you mentioned that. I was speaking with another agent the other day, and she said her and her husband were talking about that. Like, they're doing all this for their kids. They're like, well, do they even want it? Like, do they even want the house I'm about to leave? Are they just going to turn around and sell it? Do they even want the business I'm creating for them? So I see why it's important to have those conversations.
I'm an estate planning attorney in addition to a father. And so I go through the whole sort of process. And my children are now of an age where they understand better. So I have a 15-year-old and a 20-year-old. And so it's a better stage in life. You start small when they're younger, you start with the saving of money and the things that are necessary, I think, to get them. But now I think it's the best time to really start having these conversations about, hey, these are the assets that I sort of have and you may want to have or keep. And let's start talking about that process and what it looks like.
I love that. I'm glad you brought that up. So what does it look like for someone to work with you? And then we will get into like what it looked like when we work together. But if somebody says, I think I need a will, I need a trust, what do they do?